today's talk, we are going to talk about the landmark judgment that was recently passed by the Supreme Court of India regarding the subclassification of scheduled caste and scheduled tribes. Today's talk, we have two speakers with us. I'll introduce both of them. First of all, we have Dr. P. Venkatesan, who is an advocate at Supreme Court of India. He has an overall experience of 15 years. He has worked in many cases pertaining to poor, women, marginalized sections across India. He has actively taken part and contributed very much in this landmark Supreme Court judgment, State of Punjab and others with Davinder Singh and others before five judges bench and before seven judges bench. So welcome, Dr. P. Venkatesan. Our second speaker is Aditya, Advocate Aditya Chatterjee. He is a practicing advocate in India, primarily appearing in matters before the Supreme Court and the High Courts of Delhi and Karnataka. He is a commercial lawyer by training. Apart from commercial disputes, he has appeared in matters of social and public importance, such as in the matter of challenging the abrogation of Article 370, hijab ban case, relocation of slum dwellers in Karnataka, challenge to minimum wage amendments for medical aid of patients suffering in rare diseases, and many more. So we welcome Advocate Aditya Chatterjee as well.
So what I'll do is I'll take a brief overall view what has happened in this issue, some historic background actually. I can say that um, during the course of Ambedkar, there were demands from different sections of scheduled caste that they should be given a kind of preferential reservations or a separate reservation, which Ambedkar has written in, he has acknowledged that one because based on the social disadvantage among the various scheduled caste groups. But when you see the history of the scheduled caste, the naming scheduled caste, it's a class. During the British rule, they were classified as depressed class, thereafter as scheduled castes. But if you can see the caste, what they want to say is this is not caste as such, but it's class. And during the Constituent Assembly debate, many deliberations have taken place, how it has been considered, the backward class. And it has been considered that it's a backward, the scheduled caste is not a caste as such, but it is uh, uh, they said it has to be decided based on the backward class. So the backwardness and it is a class in fact. Thereafter it was so what I'm saying is this resulted into the definition of the scheduled caste by Article 341. Thereafter scheduled tribe into 342 and the recent amendment has taken place 342A with respect to socially and educational backward class. So all these three is article has to be read so that to understand it. But it's a deeming fiction. There are two things that I want to specifically say this one. Whatever we have the caste system in India, that is different from whatever that has been understood from the caste system in constitution. So this is very important thing. Actually, people want to map one to one from this frame of caste system to the constitutional frame of caste system. What I am saying is constitution has abolished untouchability. So, and it doesn't recognize any kind of untouchability by law. However, if anyone practices, it has to be understood from the and it has to be tried under the different sectors. That's the one thing. But here it's a deemed fiction. That's what many judgments were there, but this is the first judgment which has frozen the definition of the scheduled caste. So it has said that it is not caste as such, but it's a class. It's a class of people. It's a deemed fiction to justify, to define it as a class. So I will read it out for a scheduled caste, then the remaining is also okay. By public notification, specify, that is, the president, with respect to any state, union territory, where it's a state, after consultation of the governor, thereby, by public notification, specify the castes, races, or tribes, or parts, or groups within the castes, races, or tribes, which shall, for the purposes of this constitution, be deemed to be scheduled castes, scheduled castes in relation to that state or union territory or the case. Very important thing. Actually, it's a jurisdictional one. What I'm saying is, it's a deemed fiction, so it may be a caste, it may be a race, it may be a group among the castes, or it may be ethnic part, or like tribes, or groups within the caste. So, our groups within the caste. That's what you can see that if you study the, then it has to be notified thereafter. It has to be, deliberation has to be taken place. It has to be recommended by a state. Deliberation has to be taken to the has to be taken at parliament. Thereafter has to be referred to the president. President will take a call and it will be published. No, the public notification will be given. I mean, GO in this one. It's called a presidential order. So that will list the task. So what I want to say is, this is a procedure, laid down procedure, how to include or exclude. But so far, to my knowledge, I don't know whether exclusion has taken place, but inclusion keeps on moving. So it means untouchability is not a criteria, very important. Untouchability is not a criteria, background is the only criteria, which they have to consider. And the background has to be decided by the state. So far, in union territory or state, they were only considering or quantifying the backwardness of different castes, groups, or trades, or whatever as defined in the Article 341 for SC, 342 for tribes, and 342A for socially and backward classes. So what I'm saying is, here now, based on 342A, the OBC list, the backward list, other states have been has been made as a central list now. So you can see a lot of developments happen in the OBC classifications. In case of BC in Tamil Nadu, and Maharashtra OBC community has been, this has been under 342 years. So what I have to say is, very important thing is, it's a deemed fiction, nothing other than that. Now, when it has become a class, first time they are treating it and defining it within the constitutional framework, whether it is a class, it's a scheduled class or a scheduled class. So it is a class. Now it has been fixed, it has been well defined, it has been class. Then if that is the case, if it is a class, this is not the cost what is, so it is a different frame. What I'm saying is, in a constitutional frame. It has to be understood from this constitution how the class, the development, the backwardness class among the scheduled class, or I can say scheduled class in a way, how this class has to be understood. Indra Savani matter in Mandal Commission case, as well as Thomas matter, it has been very well defined that classification among the backward class is permissible under the law, and it has to be quantifiable and it has to be justifiable. So it should be reasonable, intelligible. So what they want to say is, it has to be decided on certain criteria. But in case of Balaji versus Mysore, they said that that just should not take in parlance with the caste systems, whatever we have seen. Just certain backward castes are um, uh, cannot equate them with the class parlance. It has to be understood from the class parlance, actually. That's what they are emphasizing, that one. And in case of the classification carried out on caste parlance has been shut down in Balaji versus Mysore, actually. But this is, we have very interesting case I want to refer. Classification has been first, when we go prior to the constitution, classification, you can see from Mysore state, where Iyengar, Tamil Nadu Iyengars migrated to Mysore Maharaja, where they occupied the seats reserved for Brahmins at Mysore Maharaja kingdom. So Mysore kingdom, where the Brahmins has been given a separate portion, a separate quantity of reservation, where once the Tamil Nadu Iyengar reached over there, they have taken the Brahmins reservations, and the local Kannada Brahmins were not able to uh, have a good number of their share in that one. So they demanded, given a representation to the Maharaja. Maharaja has considered that thing, they bifurcated into equal parts. In the sense, half of the Brahmin reservation will be given to Iyengar, and up to uh, local Brahmins. So you can see that connectivity. Even among the forward castes, or you can say, such classification was there in the list of classification. I will say to ensure that a representation has to be given. The Constitution is not a poverty alleviation program. From the perspective of reservation, I want to say it's a democratic representative program. So, for that purpose only the reservation is given. So, everyone from different backgrounds or different classes or different social background, they should be accommodated for the for in the government services, so that everyone's contributions and views will be taken into consideration. That is the main purpose behind this one. And whereas in case of economic development, that's a different issue. Here, after considering this one, many we can see that more than 10 reports, around 10 reports and commissions, and 7 to 8 commissions were there across India considering the subcategorization of scheduled caste. We can say Lokur Commission report was there that some communities among scheduled caste were more advanced, then they were not able to uh, uh, give the opportunities. There is no opportunity for the most disadvantaged communities or less developed communities to take part in the reservations. Thereafter, uh, we can see case of Punjab and Haryana, where one by way of notification in Haryana has been given for actually very interesting thing is notification for sub-classification to implement in reservations of government sector, like government participation, where two cases have been the main case before the Supreme Court. One is Punjab Act, which has been challenged after in Chennai. I'll say what is actually happened. In Punjab and Haryana are similar cases only, but in case of Haryana, where they categorize scheduled caste into class A and class B. I mean, category A and category B, where A as this most disadvantaged groups and B as uh, relatively advanced groups. Within scheduled caste, this relativity has to be understood from within the scheduled caste. In the say advancement actually, in the say classification within the scheduled caste. Same is in the Punjab also they have given, but very interesting thing. They are also 50%. So in case of Punjab, Majbi Sikh and Balmikis, those people are most disadvantaged communities among scheduled caste. Whereas in case of Haryana, the similar things have been grouped actually into two classes, A and B. So when A is not there, then it can be given to B, and when B is not there, it can be given to A. It's a kind of uh, what you can see similar in type of Tamil Nadu. In case of Punjab, also similar in case of Tamil Nadu, what they are called privileged reservations in Tamil Nadu. In Punjab, that is the case right now, adopt that. But it has been challenged after Chennai. What is interesting behind Chennai is that in the Andhra Pradesh, you can see that in Andhra Pradesh, there were many groups among scheduled castes where they are most disadvantaged and more disadvantaged among them, and they were considered in demanded for classifications, sub-classifications, which has been considered after the recommendation by Justice Ramachandra Raju Commission. Actually, it has recommended, and thereafter the government has notified and introduced classification, and thereafter by way of law subsequently. It has been challenged before the Supreme Court, and it has been challenged before the High Court. The High Court did not go against classification, whereas it has been challenged against the High Court order before the Supreme Court. Supreme Court shut down, saying it is a homogeneous class. So homogeneous is single unit. So what they are trying to say in the UV Chennai is, since it is backward in itself, there is no further classification is required. But there also it has recognized it's a class, very important. UV Chennai also recognized it's a class. And now there is no new definition has been given in this 7 judges constitutional bench, but they have well defined it, chosen its definition in a way. From because there are many, even all the Dalit intellectuals, whatever their literature I am seeing, they want to connect, they want to map, or they want to say whatever the caste systems they are trying to see here is same that has been adopted in the constitution as a scheduled caste. That's completely wrong. Actually, it is a class in constitution, whereas that's a caste in case of normal social order, whatever caste social order is. But connecting mapping is also not appreciable. That's the one I want to say. And it's not permissible under law. But once a caste in a social caste system will become a class when it comes or recognized or enlisted under scheduled caste. he becomes a class. That caste will become a class. But this is what missing gap in the among the social. What I'm saying is sociologists, Dalit intellectuals, everyone, even other intellectuals also. This gap is missing actually. Now it has opened the Pandora box actually. Now the Pandora box has been opened. That's class. Once the class has been there, then quantification has to be decided based on the advancement or less advancement or most disadvantages. So the quantification has to be decided. How, I mean, we can say determination of backwardness or quantifiable backwardness. This is what this judgment says. Since it has been there, become a class, now it has to be understood from the it has to be understood from the Article 14, 15, 16, and 38, uh, and the other articles like the 341, 342, 342E, uh, along with other articles. But these are very founding articles to understand this uh, things. What I am saying is Article 14 says that among they observe that among among the unequals among the scheduled class, it should be not possible to consider them as a single class. It has to be reconsidered. Then there is no bar, and the competence is there on the state to carry out a classification, but on a quantifiable manner. Very important, on a quantifiable manner based on the data. That has been upheld by 6 judges in concurrence with slight variations, but dissent by one judge, uh, Bila Trivedi. So we can see that this dissent is upholding the what is called E.V. Chennaya. But interestingly, with only one thing, I will say only, but there are certain things. This case is not just on what we can say is similar issue. The issue before this sound judgment is very simple issue. Whether this is a class, or if it's so, whether it is a single class, or if it's so, whether it is sub classification is possible or not. The judges, judgment has happened that is classifiable, sub classifiable, but it has to be based on the judgment. What? And now it is open. Now many states are in demand. Um, but it said it is up to the state to decide whether it has to be preferential or inner reservations. They will decide based on the data and the background state. This is very important judgment.
Thank you, Dr. Venkatesan. I think we will continue more. We will now move on to the remarks from Advocate Aditya.
Okay, thank you everyone for this opportunity. I'm happy to be here only because I've taken back to 2016-17 when I had the good fortune of being the part of the initial meetings of AKSC, and it's nice to be back again. Unlike Dr. Venkatesan, I don't have the privilege of having worked directly on the case. So therefore, any remarks that I might have is a third person view, and it's a legalistic analysis from what the judgment says. So I will defer to Dr. Venkatesan on most of the foundation that he has laid. And as he has pointed out, this was a 7-judge bench. The majority formed of 6 judges with 1 lone dissenter. When we look at this judgment, I think it is important also to keep in mind that there is a purely legalistic and black letter constitution way of reading it. And there's also a manner in which it has to be interpreted in the social context. I don't feel very qualified to do the latter, but what I'll try and attempt is to see how the constitutional reading of it plays into the social realities with which reservation was initially intended as in the constitutional scheme. I think Dr. Venkatesan's already spoken about the majority as to what the judgment has done. I just want to give some context for it, and I will mainly concentrate on the dissent of the one lone judge, Justice Bela Trivedi. The whole issue arose actually because of the judgment in E.V. Chennaya. See, this judgment came up because of the subclassification that was attempted under the Andhra Pradesh Act. And the court was called upon to decide whether state legislatures have the power to subclassify based on the felt social realities in that particular region. What the five-judge bench in E.V. Chinnaya said is that you cannot subclassify, and the schedule that we have is actually under the constitutional scheme only a deeming fiction. It is not that this can be replicated in society. Under Article 341, the power has been given to the central authorities led by the president to identify caste groups that can be identified and put into this list. And once put into that list becomes cast in stone. The list can be obviously included and excluded, but that list is one homogeneous whole. There are no differences inter se. I don't think the judgment has made an attempt to determine, based on evidence, whether there are any differences between the various subcategories or not. But at least for the constitutional purpose, E.V. Chinnaya's position was that this is one whole class and it cannot be tinkered with. And this word tinkering finds reiteration again and again, both in the majority's view and in the minority's view. The minority's view is that, look, once the constitution had a construct and has put that in place, and that power is given only to parliament led by the president, then state legislatures must necessarily be kept out of it. Justice Trivedi's analysis is primarily coming from the perspective of who has the power to even deal with this. It is not going so much into the question of whether this is desirable, whether Article 15 and 16 that provide for reservations to be provided and made so that there is social representation, that analysis is not really there. Her analysis has primarily been about how this cannot be interfered with, tinkered around with, because to tinker around with the powers that flow from Article 341 is to tinker with the Constitution itself. Justice Gavai, though, who is part of the majority, looks at a slightly more takes a little more social view of it, which is to say that the genesis of this subclassification or classification, or even having a schedule in which the castes are notified, is all coming from Article 14, 15, and 16 of the Constitution, where there is an obligation and the power has been given to Parliament, to the states, to lawmakers, to say that where there is underrepresentation in society, where there is underrepresentation in education, where there is underrepresentation in employment, reservation can be provided for to any of those classes. So the use of the word any also would be of some importance, because would any then mean that if there are a bunch of castes that have to be notified, each of them forming an integral part of the word any that has been used, then wouldn't it be only logical or rational to say that based on the felt realities of that place, you should be allowed to provide for those felt realities, respond to those realities, and adjust the manner in which reservation is being given through subclassification. Justice Gavai's basis, he also draws from some of the speeches and writings of Dr. Ambedkar, and says that the reality of providing social representation cannot be blind to the reality that there are differences within this classification itself. And those classifications are best understood by the specific regions, and they must be given the power, and that power is anyway there to provide for those realities, so that groups that are differently or underrepresented. So the difference that they try to draw out is that there is certainly social backwardness, but there might also be a section of further backwardness. And this distinction, if forgotten, may not fully do service to the idea of reservation that is the core of Article 15 and 16. This dissent can be contrasted with the reason I think this dissent is interesting is because just a few months back, earlier last year, there was the judgment in, there were, as you might remember, there was a judgment in deciding the validity of the economic, so-called economic weaker section reservation that was brought in. There also, there were two dissents where the court noted that the point of reservation is not necessarily some sort of poverty elevation scheme. It is with a very specific intention of ensuring social representation where there has been social boycott for centuries. And in a sense, the majority in the economic reservation judgment and the minority in this particular judgment are towing the same principle, which is to say that this has to be looked at purely legalistically as a deeming fiction only, removed from the social realities in which Article 15 and 16 operate, and removing it from the basis with which the list was introduced in the Constitution for the first place. And that, without really venturing into an opinion, I feel does not answer one aspect that the majority brought out, saying that even if this tinkering has to be permitted, it has to be done on a very strict basis, which is to say that there must be data available, data must be collected. Based on the data available, policy decisions must be taken. And if that policy decision is subject to scrutiny, judicial scrutiny or public scrutiny at some point, you must be able to justify the position taken based on the exercise that the state has gone through in collecting the data. This aspect I feel is positive in the sense that it, if not directly, at least indirectly encourages that the development, the current social status of the various communities that are included in the schedule actually need to be investigated, looked into, and data needs to be collected and maintained. Because on one hand of the problem has always been the insufficiency of data. There has been resistance in the past in other forms to collect data that pertain to the communities that fall within the SC schedule and the ST schedule. This judgment gives half a signal, saying that if these decisions for subclassification is based on material and data that is available with the state governments, then it can be justified on that basis. And that is how the reference that came as to whether E.V. Chinnaya has to be revisited was answered by the majority in the positive, saying that yes, it has to be revisited. It is not one homogeneous whole. There are differences in between. But if those differences have to be catered to by making any special provisions as provided for in Article 15.4 and in favor of any backward class of citizens as provided in Article 16, then I feel the majority is probably right in saying that you cannot be blind to these differences. The minority therefore takes a view of a purely legalistic one and thereafter treads beyond the reference to introduce issues of economic emancipation, which is, at least from my understanding, not the purpose with which reservations have been introduced. And reservations taken out of its social context, taken out of its social history, and taken out of the constitutional purpose with which it was introduced, and being reduced only to a legalistic understanding of what the schedule is and what it shouldn't be, will not give us the true spirit with which these provisions were introduced into the Constitution, and will lead us astray to think of it as either a poverty elevation scheme or limiting it, or introduce concepts as have crept into this judgment also, which was purely only answering a reference. I think the issue of creamy layer has also been raised, which doesn't necessarily arise from the questions that were put to the bench. And there has been also a reference made to saying that how it should be limited to one generation or one class that has already had the benefit of reservation, singing the same, which takes the same line that had been taken in the economic reservation judgment, which I feel misses the social context and the social rationale with which reservation was introduced as a constitutional concept. These are my views based on the readings of the judgment. Like I said, these are, unfortunately, I'm handicapped by only reading what is there in the judgment and do not have the advantage that Dr. Venkatesan had as being one of the advocates in the case itself. I'm happy to hear his views on it, and of course, share the thoughts of everyone else who's in this meeting. Thank you so much for this opportunity.
Thank you, Advocate Aditya. Thank you all for coming. Now, let's dive into some of the questions that we get in the chat. So, the first question is from Vajra. They are asking what will be the impact on rooster system through sub-classification. And they are also adding some context saying, as backwardness has never been the criteria through when the reservation is given, how can Article 16.4 have been invoked? So, Dr. Venkatesan, do you want to take that question?
Rose system is thoroughly different context, actually. 16.4 is an enabling class, enabling article, you can say. So, whatever, so the reservation, whatever the government is a scheme, very important thing I want to say you, many people are demanding that it should be proportional to the percentage of the population of the SCS. It is not like that. It is at the discretion of the state, based on different criteria, they can decide the quantity of quantum of reservation that can be allotted. Because in case of all, I am saying, in case of Punjab, Haryana, there is a case. Actually, their percentage is more, but they have been given 25%. Though their percentage is more than 32 to around 32 to 37%. But in case of this, the issue is we cannot have, though it has been implemented, we cannot have, what I can say is direct. For example, if there is this much percentage, it has to be done like this. It is not like that. The 25% is been earmarked, for example, then it has to be done at the time of notification. But if there is a vacancy, it has to be done. That's a backlog vacancy also has been included, and now it has to be taken for carry forward. But let us see that process is very different. Right? That has to be done. How to implement it? Who has to come first? Who has to come next? Those are the things actually. It has to be. That's another way of implementing this one. One is quantum of reservation. One is the backlog. One is the row system. Row system will give a different way. It is not trying to take away or trying to give a confusion in implementation. It is trying to streamline such a way. For example, the row system in different states are different actually. And that will try to give a way that preference should be given among this backward class or among the reservation, how the preference should be given to the third class. That's what my understanding about that one. That's no way this way going to affect that one. Very interesting thing they said, this subclassification is no way going to exclude or include even the people who are in this list. So in this way, even the reservation what is they are going to implement is no way going to impact by this subclassification or even by the row system. Yeah, I think I answered
Got it.
to some extent.
The next question is, can these comments by the judge of Supreme Court be taken as precedents for any kind of legal arguments against existing reservation architecture that state follows, where in some cases the state reservation is greater than 50%?
I feel the judgment will have to be viewed in its context, where it was answering a very specific reference because of on the question of whether a previous judgment's holding had to be revisited or not, and that was also limited to what is the character of the power under Article 341 and the schedule that is introduced. So my understanding based on the reading of the judgment would be that no, this should not be read as a precedent for any such argument that suggests that you take away social welfare protection that has been constitutionally introduced. Rather, this should be read as a judgment that only strengthens and concretizes the basis on which reservation is a constitutional scheme.
Yeah. Dr. Venkatesan, you want to answer as well?
Yeah, as he said, uh, precedent to what extent? It may be case to case basis. Actually, in case of EV, here this will become a precedent only for subclassification, because here in this judgment, before taking up the matter, the judges said we are not going to get into larger issues. We are going to focus only on classification issues. Two issue is only, what I'm saying is whether EV is correct, whether subclassification is correct. That's it. In future, similar case could definitely arise. This will be the precedent for that. And this will be precedent to the contest of each case. As there is an issue of quantifiable data, they have raised the issue, then they will take this one. But there's an issue of subclassifications or subcategorizations or preferences. This judgment have very categorically said that how you are going to implement is not the issue, and it is, and how much quantum of reservation is not going to be an issue. It is given, and it is at the discretion of the state. So in such cases, this will be a precedent to some extent to the similar issues, not to the varying issues, but it may be referred in some other cases, which has a kind of connectivity. In case of um, other backward classes case, it has been very well referred in this matter. A certain portion, like that, it may be referred. Not completely, it cannot be completely ignored or cannot be completely present. It depends on the case to case. That's what my understanding.
Got it. Thank you. Uh, so there's another question part of that is uh, in this new judgment, will there be the financial dimension that will be introduced into the current caste reservation model? So what is the criterion, right? That's what basically this question is implying. We know it talks about socially and educationally backwardness and having effective representation. Will this judgment introduce financial dimension, the economic condition into the reservation model?
Actually, as I said that this case pertains to smaller issue of subclassifications. That's all. But it did not go in deliberation in detail about the, what I'm saying is about the theme layering. Those are a kind of suggestions or opinions that cannot be implemented. That will be a future case. A lot of Dalit organizations started focusing on theme layer issue that has been raised in this judgment. That is not so actually. That is not a question at all in this judgment. They are referring actually what could be the consequences if they are not considering the theme layer. It means the sense it is a proposition, it's a kind of opinion or proposition, suggestion, but it's no way going to get any impact right now. But it is at the discretion of the still it is at the discretion of the state, because every state has their own criteria of capping limit for getting scholarship for SCSs right now. Very important. But that capping limit is not preventing them to get the admission, what, not preventing them to getting admission in the education, but there is prevention in getting them scholarship right now in every state. But it doesn't prevent them even getting into government jobs. But this capping limit is, the proportion of capping limit is in future, but they did not say how much quantum out. Very important. They did not suggest how much quantum, but this may be considered by the government, because there are demands from different organizations to increase the quantum, this for this present purposes, but that will be not easy at this moment, because there are different um, opposition from different organizations for introducing the creamy layer. It is not possible at this moment. And I will say one more thing. There are few cases, at least I remember one case filed before the Supreme Court to implement what they call creamy layer in SES. That's pending. That's registered and pending. So I don't think that, but it will go like this, and many people will intervene in this one, are in play. Yeah, thank you.
Got it. Arul is asking a question with the current judgment and the comment about creamy layer. Do you think it will improve the representation or one step towards killing reservation? Not about the legality, but the your personal opinion from both the case. What do you think would be the impact? So
As
Aditya, you can go first.
Yeah, when Dr. Venkatesan pointed out legally speaking, the creamy layer issue does not arise here. And maybe to that extent, I would also feel that while it has been discussed and, there has been an indication here and there in the judgment, I would feel that was also unwarranted. And I also feel that this cannot be looked completely removed from the judgment that came last year on the economic reservation aspect, because the same arguments were raised there also, introducing a very different dimension to the basis with which reservation has been conceptualized in our constitution. I don't, yeah. So to answer the question, I don't think this judgment impacts it in any way. But by mentioning it, it has made it a conversation point. And I feel that is also a bit of a overreach given the context of this judgment.
Dr. Venkatesan.
Yeah, similar kind of observations, opinions, suggestions are there in different cases. You have to see. But at least it is at the discretion of the state to implement it or not. But this will never be having any influence on taking away of reservation, because that will have different repercussions socially. You can see that one. Even just by mentioning a suggestion or suggesting as a creamy layer should be considered, you could see a lot of different voices against this judgment. They did not speak much on subclassification, but they spoke much on creamy layer. Though different organizations or political parties voiced against subclassifications, mostly Dalit parties actually can say. Dalit parties voiced against subclassifications. And very interesting thing I'll tell you, the scheduled cost list is a state-wise list, respective state-wise list. If they go into other states, they cannot enjoy the same benefit in the other state, scheduled cost list. So by this means, what I want to convey is the jurisdictional issue. But they can enjoy reservation in central list. I mean, central government education and central government employment, but not in other states. So when they go and try to use to other states, they lose the reservation. They don't have the reservation. They have to compete with the open side. That all SC people they have to understand legally. I'm talking about legally. So this reservation is implemented in the respective state. For example, there are two states which have for same community. X is the scheduled cost in the state A. Y is the scheduled cost in state B. Okay, I will say X is the same scheduled cost in two states cannot be considered equivalent. There are many judgments to this. And very interestingly, I will say, within the group among scheduled costs, they are scheduled costs in certain districts and they are backward class in certain districts and they are most backward class in certain districts. So there is no standard fixed. Even the classifications of certain castes or groups or race or whatever, it's a scheduled caste. Because the backwardness is considered with respect to the district, the backwardness with respect to district to include them the scheduled caste or not. So it's a complex issue. We cannot give answer to this one, complete clear answer, but I can say that it cannot take away the reservation from this
Got it.
perspective.
Vajra is asking, what will be the impact on the social homogeneity and the bargaining power of the scheduled caste with the state due to subcategorization? They think that this is against the views of Ambedkar and the Pune Pact through which it came. So the question is, what will be the impact on social homogeneity and bargaining power of scheduled caste and scheduled tribe due to subcategorization? Aditya?
This is first. I must acknowledge that I don't think this question would find any discussion in the judgment itself. This is really I think more a question of what is the impact of this judgment, and the arguments that have come after this judgment which criticizes this judgment. The criticism has been exactly this, saying that there is a homogeneous class, and by introducing what has been now seen as a ability to tinker around with and create artificial competition within communities that are already part of the schedule, there is an attempt to break the homogeneity. I do not have a um, I do not have an intelligent guess on this. But what I feel we should look out for, and which comes from the judgment, is the judgment says that any attempt or any action to create subclassifications must be based on extremely rigid, hardline, data-based, evidence-based exercises. And it is on a scrutiny of these evidence-based exercises that a decision to subclassify, when challenged, will either be given the green signal or will not be approved and will be struck down. And my hope is that the homogeneity of the class is not interfered with because of this, out of court signals that this judgment has left. But at the same time, any decision taken will actually be based on what the majority says, which is based on data and evidence. Which I also hope the next step of this will be in actual seriousness in collecting data on the social realities of the communities that fall within the schedule.
Dr. Venkatesan?
I think this question is out of this judgment, if I'm correct.
Mm-hmm.
You political representation is a total bargaining power of all the social cost and social collective. This is a representation in employment. This is a reservation case of employment and education. But it will definitely have repercussions in political representation. This is a deliberations that has been discussed during the Constitutional Assembly debate. Very emphasis has been given that besides reservation for these backward classes, political representation has to be given. That is more primary than the present than the proposed reservation for employment and education. The reason being, even if it has been given in employment and education, unless the political representation is not there in the assembly or parliament, their voice won't be reflected. Very important. Now, whose voice are not reflected in all parliament and assembly across India, only most disadvantaged scheduled caste and social tribes. That's only. After judgment application of full, and now this will strengthen further everyone's participation. Now, for example, to give a data, I'll give only one data. In case of Tamil Nadu, there are three major castes in Tamil Nadu among scheduled castes. One is Parayar, Pallar, and Kshatriyar. Of these three communities, I'm saying it because there is a data. I have just seen the Justice Janardhan Commission report. Only hardly out of this 72 or 60 to 65 years during that commission report of submission, only 2 or 3 MPs from the Arundhati community were there for almost for 65 years. Only three. Though they are 1/3, they claim as 1/3. But majority has been from Aditya communities or Pariyar. Very important. And few Pallars. So it clearly shows now this will push for the political representation and go for strengthening the collective voice. This will definitely push. Already in demand. And now we can see that the present government, both the center and even at the states, different states, they are trying to rationalization of political representation of underrepresented or most disadvantaged groups of scheduled caste and scheduled tribes. Now you can see that one. So this will have definitely impact to give priority or to accommodate underrepresented scheduled caste and scheduled tribes in political identity.
Thank you.
Voice will be strengthened. Important thing is collective voice will be strengthened. It won't be hello. Am I audible?
Yeah.
Now the collective voice that they are saying they are dividing that wrong actually. They are strengthening the. I can say I won't use the word Dalit because that will have a different connotation. This judgment will have a collective and strengthened voice of every section politically also. It's not going to suppress or divide. It will collective because now there were some scheduled caste people are asking who should be enhanced, that reservation should be enhanced, and their voice should be their representation should be increased. But the most disadvantaged groups are not going to them in a way, not supporting so much collectively, because even if the reservation is given, who is going to take away that reservation? It is only you. Why should I watch for you? Unless my charity. This is there, I can see across India. Now, once the subcategorization and classification is given both in education and employment, this will have replications in political representation, so that the strength of the collective voice or the voice of the collectiveness will be more stronger in a way, more voiceable. That's my view.
Yeah, we have a Raees from Dalit Camera, whose paper was cited in the arguments, and he's here.
JBeam actually. I want to just give a comment on this judgment itself. See, this is a very progressive and it's an anti, and this is against the entire question of anti-caste movement. It questions the anti-caste movement. That is how I see it. For an example, it justifies. What do we all say is we are homogeneous, homogeneous, homogeneous. We were never homogeneous. Show me data that we show me one village in this country where Dalits treat equally. And there is a study which says that whatever study, minimal study which the Supreme Court quotes, it quotes about the Gujarat case, which is Navasarjan and the Robert F. Kennedy did it. For that study which Navasarjan did, he lost his NGO because Dalits went and harassed him so badly. I met him in Mumbai to take an interview for Dalit Camera because I said that is a very good report. That is the only study was done. Because you should know, in India, all the NGOs are monopolized by particular caste. That NGOs and no funds for if a Dalit from a scavenging caste or somebody starts, there is no fund for us actually. So we have to go and beg with them, beg with this caste upper caste. For the sake of argument, I'm bringing upper caste. So they bought a report called about Gujarat study, and that study says they point out list of discrimination in 159,559 villages. In that villages, they find SCs and SCs versus the BCs. There are some 98 point of discrimination. Within SCs, there is 99.9 discriminations are there. And they say there are some marriages between the BCs and the SCs. But within SCs, there is never a marriage. See, one thing all of you should remember. We were never a brother and sister. We don't want your brother and sister relationship. We want son-in-law and brother-in-law relationship. This brother and we are all brothers, we are all sisters. That is a patriarchal relationship in a family that you can never marry a brother and sister. So the Dalits argument that we are homogeneous, there is not a single data. There is never a single data. You cannot take one village and say one person, this one progressive Parayar is there and he is protecting the entire village. That can now never be a case. I can show you thousands of Brahmins, thousands of caste Hindus who support anti-caste movement. Can we say that generalized a statement of that? So in case they have to bring data, they would bring that such data. But let them show. I'll show you thousands not. I'll ask them to come to me, come to one village. Let them pick and choose. That village, I'll show them how caste discrimination exists. So because of this homogeneous category, the scavenging communities issues were never addressed in this country. You just think. But after Baba Saheb, no MPs and MLAs or social movement or anti-caste movement never raised the scavenging issue. In 20th century, in 16th century, the water commode was introduced. But the manual scavenging was still there 1990, where only a Bejawada Wilson should come and address. Even now, Bejawada Wilson from the South India, because at least he got some kind of a knowledge because of different ruling in the background and the Christianity. So many things happened in the South. So there was some because of that, because of Christianity only, I'm also got educated. Otherwise, I would have not have any money. So some kind of a security we all had from the South. So we could study and we are addressing the issue. See, the judgment actually, SC subclassification was successfully done in Tamil Nadu and because of Dravidian land. And then it goes to the Supreme Court, and the references for that was made by South Indian scholars. And then the Gujarat, when the discrimination was published, that completely NGO was completely gone. The second issue is Dalit Murasu. Dalit Murasu was a very big magazine, Dalit magazine. They published that issue of Karadi Chittur, where Parayas go and rape Arundadir women. Let me ask you one thing. When a Parayar woman rapes an Arundadir, Parayar men rapes an Arundadir woman, how many of the Parayas go and say that, no, he's not my community? But VCK went and said, that is also in the paper, VCK went and said, don't bring this out because it breaks our unity. Where is our unity? I can't see this unity which is an abstract. Just before the judgment, 5 days before, a Chakliyan boy was beheaded that time rape actually. Now he was beheaded. His head was chopped and threw away 100 meters by Pallars, Devendras. How do I address this issue? When you say this is a subcaste, you see all the Dalit writers, Dalit studies, I've been arguing. Dalit studies always, when they write about pariahs, they write, what do they write? They write pariahs. When they write about chakras, they write subcaste. Whose caste I am? Who am I to subcaste? If you say scheduled caste, there are many castes, then everyone is subcaste. But they say I'm a subcaste. Subcaste of whom? So therefore, when you reduce this as a subcaste, you're not letting others to come and join the anti-caste movement, which Arundhati are taking it up. So I think that is where it says atrocity happens among Dalits. Atrocity is there. Discrimination is more there. So therefore, there is some data which is available because you will never let that data to come. And Dalit Murusu, when it published, they again VCK public meetings. He went and said, "Those who read Dalit Murusu are never my brothers." So Dalit Murusu is completely dead. Why? Because he spoke the violence among the Dalits. So within the Dalits. So therefore, I am arguing all these years we are fighting to say we are not one. We might be ideologically questioning, but we are heterogeneous community. And Supreme Court judgment clearly says we are heterogeneous, whatever the minimal data they have. But do you have data for that we are unity? One. For anti-caste, I'm asking, all of you, the primary text of Ambedkar, you take Ambedkar and you throw away everything. Even for intellectuals, I'm asking. Annihilation of caste text was written for whom? It was written for Janpat Todal Mandal and Hindu leaders, Hindu crowd. And Dalits are taking that as a Bible and throwing it to anti-caste caste Hindus, and they're not taking. They're saying that it is it's not my responsibility. Okay, let me ask an anti-caste annihilation of caste. Ambedkar talks about serious things. Sitting, he's saying we are not able to. Among Dalits also, they're not able to sit. Marrying, he's saying we are not able to marry. And walking, slippers. I can't wear slippers in Pariya Teru. That was all there. And I can't even tie my dhoti. I can't drive cycles. All discrimination, even many discriminations are. That is my day-to-day discrimination. See, caste Hindus you are meeting not every day. You might meet when you go to a market, when you go to access the road. I meet him every day next to my house. It is psychologically affecting me. My friend was a Paraya next to my door. What he did is he was very close friend of mine. Even now he's close, but his mother will say, "Don't join in chutney." He is a scavenger son. So his ideas, everything would be there. Won't that affect me? Because you say homogeneous, you are not trying to bring this out issues outside. So that is one. So that is very primary. So I say anti-caste annihilation of caste text is not only written for caste Hindus, it is also written for Dalits. So Dalits, with this judgment, it is going to say clearly that they have to revisit their anti-caste philosophy. One more thing is, I actually think that my paper, my admission, everywhere I was stopped because of caste issues within the Dalits. So I'm taking it very personally. If you want to know, go to Rohit Vemla's movement. Go to JNU. How many in the ground? You want statistics, right? I'm giving you how many statistics you want. Go to EFL University. Aren't there a Mala Madhya movement? And in that Madhya movement, no Pakis and release and other people, scavengers are not there. Do you know that? So there is already a statistic on visibly is there that they are divided. They are different castes and they have different histories. So therefore, they are never a homogeneous one. About the roaster, somebody was asking. The roaster, see, there are yesterday, Thirumavalavan in Tamil, when the judgment came, Thirumavalavan said that I really welcome the judgment in Tamil. I welcome the judgment and one instance of giving the right to the state. Yesterday in English, he's writing, I'm opposing the judgment. And he's writing a letterhead, on his letterhead, he's writing to Ramdas Athwade, asking him to appeal this case because it is going to completely remove SC reservation from that. So second thing, so that is two double stands. So second thing is if you come to this south, I'm also opposing creamy layer. That is what my initial stand was. So now I support, I don't know, because I always want to say what people who do not have voices whose voices are never heard. So in that Madhyas I spoke. Madhya, Jupaka Shubhatra, all Madhyas, Valmikis, all of them are saying that we support the complete judgment, not even creamy layer. They are saying one reason that Akka was telling me. If you want an interview, you can take her. She's a big writer and very important person among the Dalit literatures and writers. So she said, Tamudu, you have to oppose Tamudu because there are among the SC, there are IPS officers and IAS officers. Their sons are coming and using all the reservation, Tamudu. We are not able to do. What I'm saying is, I'm not asking you to give this reservation to the out category, general category, or OCs. They are giving among the SCs, right? Among the pariah, lower pariah, among the pariah whose income low, let him get it. Or Chaklias or whomever's there, let him get it. Second thing, about the roster system, about the somebody was asking on roster system. Tamil Nadu is an example. That document I can send you. The document says 100%, 200% roster system. It says there is certain percent of the roster will be given to Arudiyas or subclassified people. So in that subclassification, if that subclass if that sub oh sorry comment if the subclassification Arudiyas are given 3%. And in that 3%, if there is qualified Arundiyas, he should be given. And if there is more qualified guys, he should contest to the SC, general SC. If there is no qualified SCs, Arundiyas in SC, so it can be given to other SCs. So there is nothing going to happen in this. So therefore, last my comment is, this judgment is uh, it's a very revolutionary judgment for anti-caste because Valmiki's never had a voice. It's and scavengers never had a voice. Even now, sanitation workers are treated as slaves, and there is nobody to represent because no malas and madigas or no malas and parias or chamas or mahars also interested to address our issues. Therefore, it is very important for us. It has to be subclassified, and more than that, it has to be said we are heterogeneous. When you say heterogeneous, when you attack us, when you murder us, I say that SC Atrocity Act also should be to be implied on all of these castes. That is a different thing, but that is the end of it actually. So thank you.
So there is another question. Since there has been so much voice to undertake caste-based survey, while taking caste-based survey, SC communities are mentioned in different appellations. In quotes, linguistic diversity, and it is very complicated. For example, in Tamil Nadu and Andhra, Adi Dravida and Adi Andhra are not caste as such. Both Adi Dravida comprises many castes, but in reality it is identified as one. How can it be addressed in caste-based survey and identifying backwardness?
I will answer that question because this question was pending for many years across South India. Not only South India, North India also, like Adi Jambu. And there is some similar words are there. I don't remember it immediately, but I will say that like what we have presently under the Constitution of India, scheduled caste. Like that, when the movement commenced for a kind of social revolution, that name like Adi Dravida, Adi Karnataka, Adi Andhra, very important. The proposition for not calling those scheduled caste people are untouchables, I can say, untouchables, in a demeaning manner. That's very important. In a demeaning manner, we should never call them. There were suggestions from different groups, including SC people, or by then I will say, by then untouchable. By then untouchable group, and thereafter even progressive people also. They said, now those people should be called in different names like Adi Dravida. That's it. Now, thereafter, what has actually happened is Adi Dravida was given to all the people under SC, irrespective whether it is Paraya, Palla, Chakliyar, other Valluva, or whatever, to the 12 castes they were given. They were just wherever they will go, they will take it Adi Dravida. Now, the opposition already come. Specifically, it has been raised by Pudhiya Tamilagam, the Pudhiya Tamilagam leader. The name should be removed, first of all, because it is mentioning only one caste, Adi Dravida. Now, the Adi Dravida caste has been championed by only community called Paraya. So, different SC people said that now you have to rename them, like in the center, or you should rename as social empowerment department or commission, like that. Now, but this is a question because of the social justice movement, the Dravidian movement that has happened. Very important thing, they asked this question whether any caste Hindus are claiming I am a Dravidian, like Mudaliar, Chettiar, Vaniyar, or non-Brahmin caste Hindus. Specifically, are there anyone claiming a Dravidian certificate? No. If that is the case, what is the need when now the constitution has given as a kind of situation for uh, reservation, equitable reservation. They propose equitable reservation. Now they want to abolish all the Dravida community and they want to get a respective subclass, a proper names, their caste names to be reflected. This has taken place in Andhra Pradesh prior subclassification. The government has issued a notification that Adi Andhra cannot be considered hereafter. If you wish to have a proper reservation things, you can claim under your respective caste. Thereafter, people who are commonly called as Adi Andhra, they have taken the name Adi Madiga, Malar, Banjar, whatever the caste, their respective caste. Now, similar demand is there in Tamil Nadu. In Tamil Nadu also, in Karnataka also. Very important. So that there, I will say that now Sadashiva Commission report has been published, and not published officially, but there also similar issue happened. Thereafter, movement has taken place. Very important. Without government notification, movement has taken place. Thereafter only, they got a quantifiable data of their respective caste. Then they found that Madigas are more in number when compared to Volunteers. Very interesting. Similar thing happened in Andhra Pradesh and Telangana. So they were able to quantify the numbers so that they can have proportionate reservation during the classifications. That demand is still there in Tamil Nadu because they raised this issue during the subclassification or no separate preferential reservation given to Arundhati in Tamil Nadu. They raised by Madiga, by Arundhati, they said the data is wrong completely. Then this candidate said, okay, fine, that's known. You start with something, then we'll see once you go for taking data sets. Very interesting thing. Now the movement will definitely that this has to be removed. And those who want to retain, they can. Accordingly, the reservation can be given. Because the backwardness of other scheduled castes are primed by the advanced studies test. That is the thing they are claiming everywhere. So the issue has been wrongly interpreted for someone's development. That's completely wrong. Appropriate development of each community, their name should be their respective can be reflected, and Adi Andhra, Adi Dravida, Adi Karnataka should be abolished. If someone wants to retain, they can retain, but with a proportional reservation also. That is the demand from SC, Dalit leaders, specifically from marginal sector.
Yeah, the next question is from Karthik. The question is, the judges quote Ambedkar. However, they never mention about reservation in executive and judiciary, which Ambedkar supported. But they mentioned about creamy layer, which is unwarranted. How we should read it?
Yeah.
No, I agree with you, Karthik. In fact, I do feel that the judgment in some sense tries to in some places be extremely legalistic and restrict itself to what is permitted, what is not permitted, where tinkering is allowed, where it is not allowed, and some transgressions that are made. Because I think I'll give you the legal basis of it. This judgment has to be looked at in the context in which it came, which is in the context of a reference. A reference does not answer questions in a very specific fact scenario. It only answers a legal question that is put by a smaller bench to a larger bench, saying, look, there is conflict between two sets of opinions, and this needs to be relooked. So a larger bench usually answers that legal question. You don't have to do too much more than the analysis that is needed to answer the question one way or the other. So the things that you pointed out, which are the creamy layer issue, or how long such a system should continue, to whose benefit it should accrue, might be seen as overreaches, while other overreaches are not being made, which is to address the actual absence of representation, even in the higher judiciary, Supreme Court, High Court, executive positions, including the civil services. I don't think either in the economic reservations judgment or in this judgment, though these might be slight overreaches beyond the strict question that arose for analysis, the court has gone or even made hints at these things.
Yeah, I say that actually you raised a very pertinent question. I will say this. This question, this demand or this appeal is pending for quite long time for SC, ST, OBCs, women representation to be accommodated in judiciary. Very important. And the present judiciary is trying to accommodate without policy of reservation. Very important. And they raise this issue. We are ourselves finding a difficulty, handicapped in accommodating these people because judiciary is a very serious job actually. We cannot underestimate that merely branding some people as a reserved people, whether whatever, women, SC, ST, OBC, we cannot underestimate them as a not a potential candidate, but we are trying to have a kind of what you call a standard, so that should be accommodated. They're trying to accommodate to their number, whatever possible. They're trying to accommodate. But now they want to have the scheme. But that commission did not consider that scheme. They raised this question. You first come out with this one. I could not find it in this act, but they did not answer for it. They were trying, we'll come out, for 2 days, they didn't have answer. But at one end, we'll try to see how we will accommodate. But that is not the thing. But the present system is, there is no reservation, but this will happen in due course. But it should be done. That is a very demand. And this judgment, I am saying, not only this judgment, even since I am associated with a lot of cases with all poor, marginalized, everyone, irrespective of the communities and caste, what I am saying is, it is very difficult for us to convince the judiciary with respect to the SC/ST matters, I can say. With respect to the SC/ST matters and OBC matters, it's very difficult for us, even in minorities also, to convince the judiciary. But because they are not able to understand the issues pertaining that one. So this judgment could have been better if 2 or more judges from OBCs, women, from marginal sectors are accommodated. Except what I understood from the report, I don't know what are their castes in the 7 judges bench. I come to know through some media that only one scheduled caste judge was there. But probably the case, but that is the need. That will be reflection of the society. Justice is not. It is the society. That's what your demand is. This demand is not pertaining to that one. This can be, by way of judiciary interventions, like NPAL, or even taking up the issue in Parliament to accommodate them, at least 5%, 5 or 10% to start with. Then it can be slowly enhanced. That's what my suggestion.